Before we kind of get into the kind of real sort of nitty gritty of things, I just want to go through the very basic thing. This is a very basic point to make, but it's worth making. So just to explain how powerful the law can be if you're willing to pursue it. So this is a very famous case called Imam v. Croydon from 2023. It was a Supreme Court case. It was a case involving a family with children where at least one of the children had quite particular disabilities. They needed a very specific type of accommodation. And effectively, Croydon, as I'm sure you probably heard in the news, are broke. And they basically said, not only do we not have enough resources to house this family, but we've got 16 other families in the queue above them. We're not going to house them. And fortunately for this family, they had some good people around them, which then basically took it through the court process. And the Supreme Court judges at the end of it all said the following: constraints on resources are not a reason for not complying with a duty imposed by Parliament. The duty owed is immediate, non-deferrable and unqualified. The fact that Croydon may not have resources immediately available to comply with the mandatory order will reflect choices it has made in the past regarding use of its general resources. And if it does not have suitable accommodation immediately available, why should it not be expected simply to call on its general resources, perhaps by borrowing money, to adapt an existing property or to rent or buy a suitable property without delay to add to its stock of immediately available resources and comply with the order in that way? So, yeah, basically Croydon saying we have no money was not enough of a reason not to follow the law. And as it says here, even Croydon had made decisions which had kind of left them in this mess. What you'll generally find is that something like 10% of councils in England are under a similar strain to what Croydon's under, but the rest are actually, they're far more flexible around how they kind of administer resources, and are actually far easier to get, to follow the law if you're willing to go down that route. So as I say, that's what a duty is. Pretty much everything we talk about within the Housing Act from this point on are duties. And this is the kind of the benchmark to what to expect. If the council has a duty to do something, it has to do it. Whether that be someone with an arson conviction, they need to house them. Whether it be someone who's got scheduled offence history, doesn't matter. The council's job is to house people. That's what the Housing Act is there for. So, just to kind of give us a bit of a prelude before we get into it, we're going to spend the majority of this webinar just kind of touching on, well, going in a bit of detail actually about the so-called 5-part test. Terms, well, I'm sure you've all heard, what is the definition of homelessness? What does eligibility mean? What does priority need mean? What's local connection and what's intentional homelessness? We will cover a few other bits and pieces as well, but that's kind of what matters. I'm sure you've heard of the Homelessness Reduction Act as well. I don't know about Will. Will probably thinks it's better than I think it is. I hate it. I would say that all it actually did was it gave even more onerous duties to councils and less resources to actually kind of follow through with them. So you've got terms like personalised housing plans, relief duty, prevention duty, stuff like that, duty to refer, which we'll come back to. In reality, if you just focus on the 5-part test as an advocate or someone in kind of advocate type role, you are going to maximise the choices for your client in terms of housing. So that's kind of what our job is, really, isn't it? About kind of maximising the number of housing options they have. They can choose what and do what they want to do with it, basically. So yeah, particularly the big one here is actually the definition of priority needs. So we will go into a bit of detail in this webinar just to explain how that actually works. It's the most complicated. It's unbelievably complicated considering how important it is, and how most people who use it will not be lawyers. So just to say, the housing officers that you will be coming into contact with probably won't be lawyers. Almost certainly won't be lawyers. Probably won't have any formal training. Often the training regimes within councils is terrible. And they'll have ever-increasing caseloads where they just basically, a lot of councils, you just simply can't get the job done. So that's kind of what you're up against. And when I say being up against the council, that is kind of how it is. This is an adversarial legal system, much like the criminal justice sector and kind of prosecutions, where you've got the prosecution and the defence, both advance the best argument they can for that person being either guilty or innocent, and then the judge decides on the kind of the truth of the case. It's the same when it comes to homeless applications. The job of the homeless applicant is expected, or it's supposed to be, to advance the best possible argument there's a duty to house. And now, obviously, most people who are homeless don't know what the law is. Why would they? And so, in one sense, councils then get away with advancing incredibly unlawful practices and kind of blanket decisions and stuff, which can be challenged if you're simply willing to do so. So that's what we're going to kind of spend a bit of time doing. We're going to get eligibility out the way first, just to come back to the 5-part test, actually, just to say, although the same issue could be relevant to all 5 parts, They are all, each test is basically taken separately. So I often hear professionals say, this person's in priority needs, they're not housing them. Okay, that might be because they're intentionally homeless. So it's possible to both be in priority needs and intentionally homeless, and that will affect how long the council has to house you for. So, and again, you might have a pregnant woman who's not eligible for assistance, as in has no recourse to public funds. Therefore, there's not going to be a housing duty under the Housing Act. So, just understand that if you kind of take it through in the following sequence, you're going to have a good idea what duty a council is likely to owe to a client of yours. And we're going to get eligibility out of the way first. There is some debate as to whether it should come first or whether it should come after the test of homelessness. In reality, I don't think it matters that much. But effectively, this is something like having recourse to public funds, or in fact, it's almost exactly the same as having recourse to public funds or not. If you do not have recourse to public funds, there is very little a housing authority needs to do under the Housing Act. Now, there might be duties under the Care Act if they've got very significant care and support needs. There might be duties under the Children Act if there are children involved. But if they're definitely not eligible, if they definitely don't have recourse to public funds, then the council's duty will basically extend to providing advice and assistance, and that is it. And that's basically, kind of here's a bus ticket back to Poland, that sort of thing. That's the kind of way they can do it. So yeah, that's kind of eligibility. Bear in mind that there will be local schemes, kind of it's a bit of a postcode lottery. There'll be local services, local charities that can help people out who don't have recourse. Part of their work will probably be around trying to get kind of settled status or whatever. But that's kind of the first thing to say. And so really what I'm saying is if you have a client and they don't have recourse to public funds, it's probably not worth pursuing the homeless application particularly robustly, because they're probably going to fall down at effectively the first hurdle. Having said that, I guess technically speaking, what I should say is making a homeless application doesn't cost anything. And so if you're not sure, make the application and see what the council says. Once you've entered that process, it then becomes much easier to then challenge bad decisions. So as I say, I just want to get that one out of the way really. As a ballpark kind of test, if your client is getting universal credit, that probably means they're going to be eligible for housing assistance as well. Almost certainly, in fact. So yeah, that's eligibility. Then we start getting a little bit more interesting in terms of the legal definition of homelessness. And just to say, if you've got questions, feel free to stick them in the chat, or if you're feeling very brave, just interrupt me and I'll kind of hopefully answer it. The legal definition of homelessness is much broader than you might realise. So obviously, when you ask a Joe Public what's homelessness, they'll think of a rough sleeper on a bench in a park or something. That is the very tip of the iceberg. There are probably a few million people in England who are legally homeless, and you might think I'm absolutely crazy for saying that. That is because the legal definition of homelessness would include people who are at risk of abuse in their own home, including domestic abuse or particularly domestic abuse, people who can't afford their rent, people who have severe disrepair issues in their property, people who are getting harassed, people who are being cuckooed, kind of other bits and pieces, severe damp and mould. And so actually, when it comes to the legal definition of homelessness, there's effectively three different categories. The first is the most obvious, where you have nowhere with a legal right to occupy. Second is probably the least significant, which is where you have accommodation, but you either can't get to it, can't get into it, or have nowhere to put it. So you might have been illegally evicted, the landlord's changed the locks, or it might be you've got home in a different country and you can't get there, or maybe you've got a caravan with nowhere to legally berth it. Then in each of those situations, you would legally be homeless. And that allows you to make a homeless application and kind of see what assistance is going to be available to you. But the third one is the most interesting by far, because it includes these other categories of people. So, as I say, people at risk of abuse and so on. Maybe their accommodation is unsuitable. They've got a severe mobility issue, and they have to go up 2 flights of stairs to get to their flat or something. All of those situations would also be included in this definition of homelessness. So, in one sense, legally, there's not a hierarchy. And so if someone is in one of these criteria, then they can make a homeless application to a local council. Which one? We'll find out in a minute. That leads us on to a question which I'm not sure if me or Will actually know the answer for sure here, but we're going to hopefully be a little bit useful here. So talking about CAS 3 and approved premises accommodation. If we talk about CAS 3 first, and again, neither me nor Will are experts in the criminal justice sector or anything like that. So maybe you guys, you will know a lot more than us, but feel free to correct us if we get this wrong. My understanding of CAS 3 accommodation is accommodation that essentially will be used to someone who is maybe leaving prison because they have no other accommodation, and it lasts for up to 84 days, so uh, three 3 months or so. And so the question would be, it's a really good question. At what point when you're staying in custody accommodation can you make a homeless application? And I can give you a definite bit of an answer, but I think there's potentially a bit more to it because if we go back a slide, if you are likely to come under any of the three criteria in the next 56 days, as in 55 days, you will have nowhere with a legal right to occupy because you're leaving the cash-free accommodation. You can make a homeless application now because you're threatened with homelessness. So that kind of 56-day period in that sense is where if you're likely to be homeless within 56 days, you are threatened with homelessness. Therefore, you can make a homeless application. But there might be a little bit more to this, and Will might pipe up here because he might know a bit more than me. But in effect, when you consider whether accommodation is reasonable to continue to occupy, and therefore, is that person actually legally homeless now or not? There is probably a bit of a symmetry between cash three accommodation and refuge accommodation in the sense that both are accommodation, but they're not reasonable to continue to occupy indefinitely. So, refuge, you're looking at something like 3 or 6 months, depending on the service. Cash three accommodation, you're looking at a similar period. And so, all I would say is, if I was working with someone who was in cash three accommodation, I would basically make the homeless application anyway and see what happens. Yeah, even on day one, even when they've got 84 days left in that project, I would get the application going now because I would want to maximize the choices for that person essentially. So, okay, just a comment coming in there. We've got to make a duty to refer to even progress a CAS3 referral. So I'm not quite sure if that's a universal requirement or whether that's a local restriction, but we're going to talk about duty refer shortly. And I expect that many of you will be surprised at how useless a duty to refer. Well, maybe you won't be surprised. I don't know. But legally speaking, as we'll see in a moment, the duty to refer is not really the best way to actually kind of start the homeless application process. So, and in terms of AP, in terms of approved premises, again, I guess probably what needs to happen in practice is the approved premises needs to set a eviction date, and even if they don't really mean it, just kind of go through it that way and just see what happens. And if the council don't sort of step in and accept an application, then maybe you extend the deadline. We've got an approved premises in Bedford, so I've worked with quite a few people coming through that project, and generally speaking, that's kind of how we've done it. So we've tied the homeless application to the date that they have to leave, even though that date is actually a little bit flexible. So yeah, Will, I don't know if you've found anything out more than I have there, or want to say anything different from what I've said there.
Well, just about class three accommodation. Um, I think the argument is, I mean, it can be made that local authorities can't say, well, you've got class three accommodation, so you can't be treated as homeless in a lot of situations because it will be unsuitable or it's likely to be. For instance, I mean, there's a list of possible reasons here, which would be it may be out of the area. It could have unsafe co-residents, incompatible. It could be incompatible with curfew or child contact arrangements, and it could be disability or access issues. I think to think about because I'll come on to this later if it comes up is the issue of post-traumatic stress disorder and what constitutes suitable accommodation for people. And I think what a lot of people are coming to recognize is that people who've been in prison are often suffering from post-traumatic stress disorder as a result of being in there. And I was just looking at some statistics, and you're looking at in European prisons. You guys probably know more about this than me, but they're saying it's about 10 to 30%. And one of the characteristics of having post-traumatic stress disorder is the need for sort of quiet, self-contained accommodation rather than being somewhere where you're have a lot of people around you. So you could start to argue that if the person is one of those almost one in three, one in four people, that it wouldn't be suitable for them because of their condition. Um, but again, it's only going to be temporary anyway. So once you start arguing about it, the longer you go on, it's inevitable the council are going to have to recognise that it's coming to an end.
Yeah, I mean, I would probably, I mean, maybe. maybe get a few things wrong today, but I would speculate that I'd imagine those figures of PTSD and other trauma related things would probably be much higher in female populations, or even higher in female populations in prison, than men's. But again, we're going to come back to that within the definition of priority need through vulnerability in a little bit. But yeah, I think, as I say, if it was me in a situation like that, I'd simply make the application, put, kind of try and get a date out of the provider to see, when they think it's going to end, and just then see what happens. As I say, there's nothing to actually lose by making a homeless application. So yeah, that's we're going to circle back to a few bits of these points later as well. But I think that's kind of our view on that. So if you're working with someone in that situation, make the application, no matter what. And then the worst thing that can happen is, yeah, you're not actually legally homeless yet, but you will be very soon. So a good counsel, when there are some, will be proactive in that sort of situation and will start planning ahead to work out how they're going to meet the needs of that person. So that's the definition of homelessness. I've mentioned the term homeless application multiple times without explaining what it is. This is almost certainly really the most important thing to understand about the Housing Act 1996, because the threshold for making a homeless application, or the threshold for triggering a homeless application, is incredibly low. So, and that's basically going to guarantee some level of assistance. So I'm not going to read the slide word for word here, but effectively you can approach any local authority in England and potentially in Scotland and Wales, though I have no idea how that works up in those other countries, or Northern Ireland actually, for that matter. But effectively, by approaching a council and triggering certain kind of criteria, it becomes a legal process in exactly the same way that buying a house would be, or getting divorced or something. And yet most people don't think of homelessness as a legal issue, but it absolutely is. And in that sense, if you walk into a homeless application situation without being prepared and without having some kind of good advice behind you, you're likely to get chewed up and kind of end up getting fobbed off and sent back out of the council again. So I mean, it's obviously completely impossible in the real world, but it would be, it would be sensible for every single person making a homeless application to have some kind of legal advice or legal advocacy on their side, because of the number of ways in which councils often don't follow the law. So just to give you a bit of an example, I won't even name the council, but myself and Will are involved in a case at the moment where it kind of required Will to write to the legal team to actually get the council to accept the application at all. There were some very unusual circumstances in the case, and the other charity worker involved in the case, I think, was actually quite surprised when the council actually said, "Yeah, fair enough." And it is just literally that thing of actually seeing it as a homeless application, as a legal process, and threatening the council with some sort of action if they're going to refuse to follow it. So just kind of bear that in mind, really. And I think there's no there's no good point to start talking about this next thing. It is unbelievably confusing how they've set the Housing Act out for lay people, as in for housing officers as well, because within the Act, and I keep talking about the Housing Act 1996, although there's been subsequent legislation like the Domestic Abuse Act, like the Homelessness Reduction Act, it's all just amending the 1996 Act. So everything we're talking about when you make a homeless application is all governed by the Housing Act 1996 itself. And within the Act, there are 7 parts. The last 2 are the only ones we care about. I don't even know what the first 5 are about, to be honest. But part 6 is essentially the way in which you get help from a council if you are not legally homeless. This is kind of the most, kind of basic way to divide these 2 parts up. Whereas part 7 applies to everyone who is legally homeless, unless they specifically want to not be treated as homeless, which is very unusual. Let's say, put it like that, because effectively part 7 is not only going to probably result in you getting housed more quickly in the long term, but it's also going to have additional duties around interim accommodation. So under part 6, if I walked into a council and applied for the housing register to get social housing, there is no urgency whatsoever with that application. Whereas if I walked into a council and said I'm homeless, there would be significant urgency, because potentially there would be a duty to house me that night. Just to kind of flag a few terms. So both parts, although very different, use exactly the same terminology just to try and confuse everyone, it seems. So terms like local connection mean different things under different parts. So if you're homeless, there's a different definition of local connection than there would be if you were not homeless. Let's put it like that. Same thing would apply around things like priority need. So priority need is exclusively a part 7 term, whereas you will see other terminology involving that word priority within the part 6 housing register application process. The other difference is worth noting at this point is that Part 7 is the same across England no matter what. Whereas the definition of Part 6, kind of, local connection and medical priority, will all be locally set by the local council. And as a good generalisation, Part 6 criteria is always stricter than Part 7. So, for example, if you're standing in Hillingdon and approach Hillingdon Council for homelessness assistance, if you're not homeless, you'd have to have lived there for 10 years to have local connection. Whereas if you are homeless, you only need to have lived there for as little as 6 months. And if you're rough sleeping or coming out of prison, potentially no time at all. Just depends on the situation. We will talk about that later. So, yeah, it's already difficult. It's already kind of filled with jargon, but there's this additional confusing element to it, which often people understandably confuse their local housing allocation scheme, the Part 6 policy, versus the rules around the homeless application, the Part 7 rules. So I'm hoping I haven't put everyone off by saying that, but yeah, as I say, you need to know it because probably one of the main ways in which professionals get confused is they'll mix the two parts up, and so they'll misapply the definition of local connection to a homeless person, and therefore kind of count them out from assistance when actually they would get it. So yeah, I'm not even kind of answered the question what is homeless application yet. 18.5 of the Homelessness Code of Guidance, which as I've explained, is the rule book for councils. It's telling councils how to interpret the law. It sets out a homeless application as being the following. So applications, as in homeless applications, can be made to any department of the local authority and expressed in any particular form. They need not be expressed as explicitly seeking assistance under Part 7, so there's no fancy language you need to use. As long as the communication seeks accommodation or assistance in obtaining accommodation and includes details that give the housing authority reason to believe they might be homeless or threatened with homelessness, this will constitute an application. So I guess that should probably say any local housing authority, because a social service authority, you can't make a homeless application to. They're not the housing authority in that area. And so some areas in the country you'll have a unitary authority where all the council services are under one roof. That actually makes it quite easy from an advocate's point of view. But in other areas you'll have like a county council, then you have individual district housing kind of council district authorities. And you want to be going to the local housing authority basically. But as it says here, you can make a homeless application any way you want. There's no particular form. There's no particular thing you need to say. You can make it to a different department, and you might think that's crazy. But again, the law has been designed to catch people who are homeless. So it might be ridiculous to expect a librarian to know how this works. If you think about it, librarians often encounter homeless people because they're using the library to keep warm during the day. And so a good council will make sure any front-facing officers will get basic homelessness awareness training in the same way they get basic safeguarding awareness training, because it can often come up basically. And the duty is very onerous on councils to step in where someone may well be homeless or could be homeless. So to kind of briefly pause and look at the reality, early this year, the local government and social care ombudsman, I'm sure you'll have an equivalent within the criminal justice system, but this particular ombudsman looks at councils around homelessness duties, and they basically did they kind of helped. They were investigating a single individual case, and they spoke to Brentwood, and they basically said, "Why did you fail this person in this way?" And they said, "Well, we fail everyone in this way." And the LGO were like, "What?" So they then did a full investigation, and over a 6-month period, 326 households had approached Brentwood Council, and ultimately only 22 of them had received a proper decision at the end of it. So something like, I don't know, 7%. I can't even do the maths on my head, but there's something like that. So an absolute tiny minority of people who approached Brentwood Council were treated lawfully, and yet each one of those individual breaches can quite easily result in compensation claims and other remedial action to be taken. So it's very common. Brentwood's not alone. Many councils do it. The main way they were actually doing it is where they're telling people until they provided certain documents they wouldn't accept the application, which is definitely not lawful. So, but there's other things to it, and you'll also get individual LGSCO decisions where they're looking at individual cases, which I'll come back to a couple in a bit. But you'll see kind of very, very common things, very common themes that councils get wrong. And the LGSCO, you don't need to be a lawyer to use it. I've used it many times in my own casework. I've got many compensation claims for people that way. And the compensation claims, they do actually improve the quality of the council support. I'm not saying they fix everything, but they also help you, in effect, get a reputation as someone who knows what they're doing. And so in Bedford, as an example, if I was to approach the council with someone, I would not have to work very hard for the council to actually treat that person lawfully. I wouldn't have to say a lot, if anything, because they think, okay, this is Mike. We need to actually kind of follow the law here. So as I appreciate, most of you won't be housing workers or have any kind of housing remit within your roles. The reality is if you don't do it, no one else will do it. So in one sense, you kind of have to become a jack of all trades, and you have to learn a bit of this stuff and use a bit of this stuff in your day to day if you want to get your clients housed and therefore less likely to reoffend. Now, the duty to refer, I've alluded to it already. It's a bit of a waste of time, although you have to do it because it's a duty. The duty to refer is something which applies to a number of statutory organisations like prisons, like probation, like youth offending services, that kind of thing. And basically, in a situation where you become aware that someone might be homeless or threatened with homelessness, so might be coming up to their release date or something, you have to do a duty to refer. No option. It's a duty to do it, so you have to do it. The problem with it is as we see from 18.7 of the Homelessness Code of Guidance, is that the duty to refer will not in itself constitute a homeless application. And this matters immensely because if you do a duty to refer, as we'll see in a moment, I've got this bit of feedback from someone coming on today, the council will email the person who's in prison who can't get their emails and say, oh, they didn't respond, we're going to close that duty to refer down, end of. Whereas if you make the homeless application, which I would recommend you do as well, the council can't shrug it off. They can't say, oh, we didn't get any contact back. It's basically on them to make inquiries. They've got statutory obligation to make inquiries, and they can't shrug off a case until 56 days has gone without any contact at all. So, yeah, and it's just a question coming there. So is there a timeline by which a council has to respond to a duty to refer? Not as far as I know. Whereas a homeless application, there's a timeline of a few hours, basically. If you've got someone who's homeless today, the council have to act today. The duty is, as we saw in that Imam v. Croydon case earlier, if I just quote it again, the duty are immediate, non-deferrable and unqualified. So there's no kind of like, oh, come back in 3 weeks and we'll think about it. It's right now if certain criteria apply, which they often will, as we'll see. So I guess my short kind of bit of a suggestion here is to say, if you work for one of those listed statutory organisations, do the duty to refer because you have to, but then follow up with an email, because you can make it in any way you want. An email basically setting out some useful information, and use that to trigger the application. Now, we haven't got anywhere near enough time to talk about that in detail today, but me and Will did a webinar back in June-ish, which was like how to trigger a homeless application or something like that, we called it. And so the recording's on the YouTube channel. One of the things we did in that webinar is we talked people through how to form their own kind of template homeless application email, because there's certain things you want to cover. It might be to say, I'm a prison officer at this prison. Joe Bloggs is about to be released. He's asked me to make an application on his behalf. Here's a copy of his consent. He's going to be homeless. He's got recourse to public funds, and here's his reason for being in priority need. If you include those basic bits of information, you massively improve the chances of Joe Bloggs getting housing assistance when they leave prison, and as I say, hopefully therefore less chance of reoffending. So yeah, there's a huge difference between in the real world between a homeless application and the duty to refer, and the reason is that the homeless applications are effectively triggered with two criteria. You have to tell the council you might be homeless or threatened with homelessness, which the duty to refer does. But you also have to ask for help, which might seem really pernickety, but that's the way the law works. The duty to refer does not ask the council for help, so they doesn't trigger the duty. So yeah, I would just bear that in mind. Obviously train a lot of people, and a lot of people have basically given up doing duty to refers because they don't work most of the time, and that the reason is they haven't actually triggered the homeless application at all, and councils can very quickly shrug them off and do nothing at all. This was a bit of feedback I got when prepping these slides from someone coming today. So another issue is communication. The housing team emails assessments and appointments to those who are detained or do not have access to smartphone. Duty to refers will be made by us, but information is then bypassed, bypasses probation, and they request it straight from those I supervise. If they do not hear from us, they close it. It's ridiculous. Not all trainees know to highlight information to be requested from probation. Just something so basic causing so much havoc. And actually what I've got here, in fact, at this point in time, I'm just going to flag one of the resources I'll share in the chat as we get through it. So bear with me a second. I've got to just juggle a few screens here. I've already mentioned the LGSCO. It's how I learnt homelessness law basically because it's written in layman's terms and it's publicly available and it basically goes into a huge amount of detail about what the law is and basically what's gone wrong. The only thing I'd say bad about the LGSCO website is that it's very difficult to search. I think if you search for a term, it just won't the search function just doesn't work properly. So what this document here is basically a database of about 200 or so interesting cases, which I've kind of ripped off there. But what I've done is I've put these keywords into the actual kind of case. So I mean, gatekeeping is something I've not even said yet, but gatekeeping is where councils unlawfully deny housing assistance. It might be because they someone applies to them for homeless assistance and they just fob them off. It comes up regularly within these LGCO decisions. This is a table where you can basically, you can have a little look. You can see what the summary of the case is. You can get kind of the keywords there that kind of help you search for stuff. It will tell you how much compensation the people or the household got, which can range from like £100 up to like 15,000, sometimes more. But the key thing here is that you can grab the code from the left column and then take it to the LGO website itself, and you just stick the reference number into the box, and then you get the full decision, which you can then read to your heart's content. As I say, this is how I learnt this law because you get the summary, you get the recommendations. If I go to the full investigation, actually, sorry, you get basically the legal background, and actually, this is probably the best resource I know of that looks at different areas of law and puts them all into one case. So this case obviously involves someone who had questionable capacity and care and support needs, and also homelessness needs. And so the LGSO explains what the law is and how it all interacts, and kind of how it should happen. So, and then it kind of gives a helpful, kind of explanation of where the council went wrong if they did, and then finishes up with sort of saying how much compensation would be paid, and also what other things would have to happen. So it might be that the LGSO say that the team need to be trained or something on a particular issue. So yeah, I'll put that into the chat as soon as I can juggle multiple screens. Yeah, Will's just put the video to that into the chat as well, so check that out. Get back to slides. How are we doing for time? We're doing all right. So yeah, so this is just, as I say, from that database. In this situation, Mr. X applied to join the council's housing register in October 2021. At the time, he was in prison and due for release. So notice here, it was just a Part 6 application. The council contacted Mr. X by email to ask for documents in support of his application, but he didn't respond to this email, presumably because he was in prison. In December, Mr. X's probation officer made a homeless application rather than a duty to refer. So that's good work on Mr. X's behalf. The probation, and so that also just to say you can do it on someone else's behalf. You will always encounter resistance from the council. One of the things they'll often say is you can't do it on someone else's behalf. You absolutely can, as long as you've got their consent. The probation officer provided more details. This is just an excerpt from the whole case, by the way. There's a lot more to it than this, but effectively, it kind of explains that the council failed essentially. Now, Mr. X only got £250 compensation because the evidence was not that he was in priority need. Because so in effect, the failures by the council weren't great, but they didn't cause him significant injustice. Whereas if you have someone who's in priority need, the compensation goes up quite a lot. So this case here involved Croydon, and that was just kind of, it wasn't involving a prison leaver, but it kind of involved the sort of situations you guys might get involved in where someone leaves prison, they're not helped by the council, they go and stay with family, cause some problems and so on. So in this case, it was actually the family member who got the majority of the compensation. They got about £7,000 of it, and Mr. X himself, or Miss X, Mr. Y, sorry, Mr. Y got about £2,000 for the gatekeeping, but that was because he was in priority need. So yeah, if nothing else, just understand the LGSO is a great way to learn how this works in practice. And yes, I know it's not your job, but as I say, if you don't do it, no one else will. Most homelessness charities don't know this stuff, and they won't challenge the local authority because they're funded by them often. So they're very reluctant to actually do anything. There's not many that would actually kind of step out really and do what needs to be done. You're probably the best person involved in that person's case to actually get them housed. Now, we've kind of very briefly outlined what a homeless application is, which is actually Section 184 of the Housing Act, if you want to know. It is probably worth knowing that. But we very quickly then get onto Section 108, which is the other really important duty in the Housing Act 1996, Part 7, which is the interim duty to accommodate. And we're just going to spend a little bit of time on this just briefly, because as the Code of Guidance explains, Section 188 requires housing authorities to secure that accommodation is available for an applicant and their household if they have reason to believe that the applicant may be homeless, be eligible, have a priority need. The way you read that grammatically is may be homeless, may be eligible, may have a priority need. You do not need to prove your case to cross this threshold. If someone walks into a council and says, I'm homeless, that's reason to believe that they might be homeless. That is evidence in itself. The council's job is to then accept that at that level and then go and make inquiries later, but they don't wait until they've got positive proof before they step in. And as we'll see, many people leaving prison will be in priority need through vulnerability, which I'll explain shortly. So just to kind of emphasise how this Section 188 threshold works in practice, this is from a case called Edwards v Birmingham. So this is the judge or judges talking. And talking about the Section 188 threshold, the threshold is low and indeed clearly low by design in view of the vulnerable individuals it is intended to protect. So this was always supposed to be an onerous duty. The fact is, councils are supposed to house anyone who might be in a priority need, find out for sure, and if they're not, they can then kick them out of the temporary accommodation. What often happens, probably like 95% of cases, is that councils deny that they're in priority need from day one, and they don't ever actually give proper consideration to the facts. And there's a whole, I do a whole day's training on this topic, just kind of on priority need. So there's obviously a lot more detail to go into. We haven't got time for here, but just hear me. Again, as a kind of rule of thumb, the vast majority of females coming out of prison will be vulnerable, and the majority of males will be. There's a reason why I think probably the proportion of females is going to be higher for reasons I'll explain in a moment. But this is why priority need matters so much, because if you're not in priority need, then there's no interim accommodation duty. And so although the council still has some duties to help, it doesn't have a duty to house. So once you've actually managed to get the council to accept a homeless application, which even that can be quite difficult, your next battleground really is to show that they at least might be in priority need. That's going to be kind of what comes up next. There is some good news within that, because many of you will be situated in services where you have easy access to psychiatric reports, medical reports from prison, or kind of pre-sentence reports or whatever, all of which will be relevant to that question of vulnerability. So there are automatic characteristics of priority need, which I'll rattle through as quick as I can, because they generally won't be cropping up as commonly as single homeless people will be in these situations. But effectively, there's 6 criteria. You are definitely automatically in priority need, no matter how robust a person you might be. You might be Bear Grylls or whatever. If you're homeless and you have dependent children, then you're automatically in priority need. And equally, if there's a pregnant woman in your household, so Bear Grylls becomes homeless and his wife is pregnant, then they're all in priority need. And same thing, homeless due to disaster. Again, if Bear Grylls' house burned down, then he's automatically in priority need. Doesn't matter that he's very robust or whatever. We then have slightly more complicated criteria. Even the ones I've covered, by the way, have complications to it. Just to say, you might as well say it, there is no minimum number of weeks you need to be pregnant to be in priority need. I've often heard housing officers say things like 16 weeks or 24 weeks. It's all nonsense. As soon as you know you're pregnant, you're in priority need, basically. The fourth one there, so you are automatically in priority need if you are homeless due to domestic abuse. I haven't got time to really kind of unpick that particularly, but just to say, if you're in your own home, you might own it outright, but you're at risk of further domestic abuse, then that makes you homeless, and therefore you're automatically in priority need. So that's kind of the main, that's kind of the most common situation people would be in that when involving domestic abuse. You've also got 16 and 17-year-olds who decline support under the Children Act. In effect, again, gets a bit kind of technical. And you're automatically in priority need if you're aged 18 to 20 and you were formerly looked after between the ages of 16 and 17 for at least 3 months. Again, very, very kind of technical definition. So the first kind of, the first 2 are by far the most common. So we've got the question of arson coming up here. So let me just kind of switch back a minute. Nowhere within Section 188 does it say the council has to house someone if they have reason to believe that they might be homeless, might be eligible, might have a priority need, and are not don't have an arson conviction. It just doesn't come into it. Duties are absolute. I've worked with a number of convicted arsonists in Bedford coming out of the AP, and the council might not have liked me for it, but they had a duty to those people. They have an anticipatory duty to think ahead in their homelessness strategy to set out types of accommodation that they're likely to need. And it's not unlikely that people with an arson conviction will pop up and need assistance from their service. They have a duty to house them, assuming these other kind of criteria apply. Same would go for Schedule 1 offenders. There is nothing in there that says particular offences would kind of count people out of this assistance. Council's job is to plan ahead and have specialist accommodation available to discharge their duties. To be honest, in Bedford, what generally happened was they'd get shunted into private rented accommodation, and kind of the landlord wouldn't really get told, which is their problem. They have to worry about. That's not my problem. But yeah, and obviously probation will kind of in amongst those kind of decisions to try and mitigate risk. Yeah, sorry, there's a bit more to this question. I'm currently seeking to house someone who has an index, whose index offence is arson. Could I please ask if homeless due to disaster criteria would apply in this case, given they started disaster themselves? Really good question. I like the question. So, I've never come across that situation actually, but yeah. So the way you'd read it is that when it says disaster, it's not just natural disaster; it's any disaster. So what I would think, this would be my first kind of my default answer here would be to say yes, they could be in priority need. However, they are going to be intentionally homeless, and they're probably also going to go to prison, I would imagine, if they're going to burn down their own home or something. So I did work in a situation where someone got very, very drunk and kind of, I don't know, kind of, yeah, started a fire, maybe accidentally, maybe not. They did get convicted for something around it, so probably deliberately, I guess. But yeah, that'd be my answer to that question is yes, they would be in priority need. However, they're probably, yeah, if they haven't already gone to prison, it's something that's almost certainly going to result in them being intentionally homeless. Will, I don't know if you've got a better idea of that answer than I have. It's a really good question. As I say, it's kind of interesting, kind of what situations crop up in questions.
Yeah, it is. It would be worth running it, wouldn't it, to say that, well, certainly it doesn't matter if it was caused by you, it's still a disaster, I suppose.
Yeah.
And I suppose intentional homelessness would depend on the facts. If you deliberately started it, then it's difficult to see. It wouldn't be likely to lead to you losing your home unless you just thought you were going to create a little fire. I don't know.
So it's really interesting. We might come back to it as well because, as we'll see with intentional homelessness, there are some things which could also mitigate that decision as well. So let's say, for example, you had you know kind of you lacked mental capacity or something and started a fire, then potentially that would mean you're not intentional homeless. But maybe we'll come back to that question as we get into intentional homelessness in a bit. I'm just kind of thinking very quickly on my toes here about how that might work because I could foresee situations where actually technically it could result in some very kind of unusual outcomes. And I guess it's probably worth saying as well, there is no wiggle room with the law. You know, when the law says a particular thing, you take it on that value. You don't kind of insert other things and think, oh, they must have meant something else when they wrote it. You just take it on the kind of facts you have. So that's the automatic characteristics. The not automatic characteristics, for want of a better word, is where it's probably the most complicated bit of the law that you would ever need to know about. There are other bits of the law which are very complicated, but you're unlikely to encounter them in the criminal justice sector. But effectively, the key word here is this word vulnerable. You need to be vulnerable in effect. But the word vulnerable within housing law means something very specific. So just because somebody is considered to be a vulnerable adult by adult services doesn't automatically mean that they're vulnerable under the Housing Act, although they probably are in reality. And so the kinds of situations which the law would envisage or kind of talks about within case law that would contribute towards vulnerability are things like physical mental health issues, which are obviously a massive umbrella of different things, disabilities, veterans of the British Armed Forces, having slept rough before, having no previous experience of managing a tenancy, being in custody. So I'd imagine it would be sensible for everyone in this webinar to probably read, I want to say chapter 23 of the Code of Guidance, which is all about people who've been in contact with the criminal justice system. So it kind of gives a bit of detail. I mean, it's unhelpfully vague in some areas, I've got to say, but it is worth reading nonetheless. And previous trauma, which again is why I probably think that there's a higher proportion of females leaving prison who would be in priority through vulnerability rather than men. Although again, yeah, there's plenty of men who have experienced plenty of trauma. But in my experience, I've never worked with a female leaving prison who is not in priority need through vulnerability, whereas I have worked with males. Being in care as a child, it might be that you're 60 years old now, but you kind of grew up in Borstal, and that's had a very negative impact on the rest of your life. That would be relevant. Risk of exploitation, substance use issues, particularly risk of relapse, historic abuse, language barriers even comes up in case law, lack of support network, and other special reason which can kind of acts as a bit of a catch-all for things they didn't really think through when they wrote the law. So all of these things are relevant, but just to say, there is no, for example, there's no physical health diagnosis that would automatically confer priority needs. So a lot of professionals say, oh, type 1 diabetes, you're automatically in priority needs. You're actually not. You probably are, but it's not an automatic thing. You always have to explain to the council how that characteristic or how that feature of that person's life would affect them if they were to become homeless. And this is where we don't have enough time to go into detail here, but I kind of try and give you a bit of a kind of a very quick summary. And we get our understanding here from a case called Paniotu v Waltham Forest, which was actually conjoined with Smith v Haringey, which Will ran. And it's the Smith v Haringey case which we actually care about. That was a really good bit of news. And the judge here says that the question to be asked is whether, when compared to an ordinary healthy and robust person, so somebody who's not been in prison, somebody who hasn't been traumatized, somebody who doesn't have a physical or mental health issue and so on, whether the applicant would suffer harm that would make a noticeable difference to his ability to deal with homelessness, which the ordinary person would not. And so this is just one excerpt of this case. There's a whole bunch of paragraphs which kind of help us build this understanding of vulnerability. And there's simply no shortcut to understanding it. You would need to kind of read these different bits of the guidance and the case law to understand how it works in practice. But really, what we get from the Paniotu case, it might have been helpful if I put this in the slides actually. In effect, if you boil it down logically, there's three things you need to consider when you're assessing vulnerabilities. The first one is, what harm do you think your client would come to if they were homeless? So it's not about diagnosis itself. It's not about a particular feature itself. They might have been in and out of prison all their life. That's not in it itself. That's not enough to cross the line. You need to hypothesize or kind of give an opinion based on what you know about that person of what you think would happen to them if they became homeless. And the one thing that's not relevant at this stage would be risk of reoffending. So risk of being exploited by others definitely would be relevant, but their own risk of reoffending wouldn't be something which would be considered within vulnerability. Secondly, would a healthy and robust person suffer that harm? So I give you a really easy example, using the example of someone with arthritis, because it just kind of makes sense. Arthritis is clearly a condition which is affected by being homeless, cold weather and sleeping on a bench and so on. So you would first of all focus your attention on what would someone with arthritis, how would they fare if they were homeless? Well, their symptoms would get worse and their pain levels would increase. Would a healthy and robust person suffer that harm? No, they wouldn't. They don't have arthritis. They're not going to have a great time being homeless, but they're not going to suffer in the same way that someone who had arthritis did. And then would that kind of harm that they'd suffer, thirdly, would the harm that they suffered make a noticeable difference to their ability to deal with homelessness? So someone with arthritis who is sleeping on the streets, clearly the harmful effects, the increased pain, the reduced mobility, is going to have a noticeable difference on their ability to deal with homelessness. That's a very straightforward kind of example, but you can take it a long way. So we did an event a couple of years ago on the channel called Trauma, Homelessness and Priority Needs, with a consultant psychiatrist and a psychologist and a judge involved in the discussion. And we talked about the ways in which suffering trauma in some way affects people's resilience, affects people's coping mechanisms. All of those kind of things are going to be kind of relevant when it comes to assessing risk when homeless. So I probably can't do it. I can't do a better job of explaining it in the time I've got today. But there's plenty of free resources on the YouTube channel. We run we do training courses as well, specifically looking at priority needs, which are very reasonably priced. But that's kind of just introducing this topic for the webinar's purposes. And then just to give you a couple of cases that would probably help you understand how this works in practice. So this is an old case which predates our current definition of vulnerability, but it was when the definition was higher, when the threshold was higher. So in this case, Mr. Crossley was found to be vulnerable because he'd been in care between the age of 3 and 17, and it was while in care that he'd become addicted to drugs. the authority had failed to consider whether his vulnerability had arisen from the period in care. So you might have someone in their 40s, but you need to look back at their childhood to work out what was going on for them. And specifically, did things that happened to them in childhood continue affecting them into adult life? And has that affected their ability to cope with being homeless or deal with the consequence of being homeless? And then the court went on to comment that although self-induced drug addiction will not constitute some other special reason, bearing in mind this is a 20-year-old case, so I don't think that even that kind of language will be used these days, where a person was attempting to deal with their addiction, the possibility of relapse was a potential special reason within the meaning of the legislation. So drug and alcohol use in general is relevant, but even if you've got a situation where their only vulnerability is the risk of relapse, that can in itself cross the vulnerability threshold and make them in priority need. Plenty of people obviously in prison have other substance use issues going on. Another case, it seems like I'm picking on Westminster today because there's a few other cases I'm going to talk about them. But in this case, Mr. Kelly was 49 years old, had asthma, back pain, depression, and a history of crack cocaine addiction. He'd also served numerous sentences of imprisonment. Since 2005, he'd either been homeless or in prison. While in prison, he was able to remain drug-free, but had a history of relapsing on release. In June 2007, he made a homeless application supported by a letter from a senior prison officer stating that remain drug-free in prison, would relapse on release due in part to his lack of housing, and that in the prison officer's opinion, he was institutionalised. Now, this is an interesting case in the sense that it confirmed a very useful precedent, which is that the expertise of the senior prison officer won the day. The housing officer had no background or any expertise at all in terms of assessing someone who's in and out of prison. Therefore, the prison officer's opinion was the one which was confirmed. And you see it within medical evidence. You see it within domestic abuse workers as well, where they'll give evidence and the council unlawfully disregard that evidence. You need to push back. If you're giving an opinion about someone in something around vulnerability, for example, and the housing officer doesn't give a good reason to ignore you, which they probably won't, because there's probably no good reason to ignore you, you need to push back and kind of fight for that council, for that housing officer to actually take your evidence seriously. Other bits and pieces. So I mentioned already, you guys might be in a good position to get pre-sentence reports. It might be you're tied in with substance use services, which enables you to get a whole load of other information about health issues in general. I've mentioned all that. So that's that slide done. That's an inadequate explanation of what vulnerability means. But just understand that I've not encountered someone who is accessing services like probation, like prison, like drug and alcohol services, who I was not able to show was vulnerable and therefore in priority needs, touch wood. So that's hundreds of people I've worked with over the years, never not been able to show vulnerability yet. And it's because I present the information that's relevant. It's in one sense, the diagnoses in themselves, the history of prison in themselves are not going to be relevant. What you need to do is focus intently on what harm you think that person's going to suffer if they became homeless, and whether that would be different from the harm that a healthy and robust person would suffer. So that's probably all I've got time to talk about vulnerability today. Let's get to local connection. So I've mentioned already that there is a different definition of local connection within the local housing allocation scheme, which is the social housing register type application process, as opposed to the definition under Part 7 when you're homeless. This is the definition of Part 7 local connection. So you've got local connection if you've lived in settled accommodation for either 6 out of the last 12 months or 3 out of the last 5 years. Secondly, you've got close family who've lived in the area, which can include aunts, uncles, grandparents, grandchildren, step parents, provided there is a genuine connection there. Thirdly, you've got permanent employment in the area. And fourthly, special circumstances. Now, very quickly, you'll notice that someone coming out of prison, let's say they've been in prison for over 2 years, they would have lost their local connection through residence because there is no settled accommodation they've lived in for either 6 out of the last 12 months or 3 out of the last 5 years. So they wouldn't qualify there. Another facet of family connection is that you actually want to live near your family. So it's not enough to have a brother in the neighbouring district. You need to actually positively want to live near your brother, which again, if you've got someone who's coming out of prison, they're estranged from their family, that wouldn't apply. I guess in most cases, they're not going to have a job coming out of prison. So you can see very easily that you would not qualify under these 3 criteria in many situations. That's when the special circumstances come in. And I don't think the guidance actually refers specifically to people coming out of prison, but it does talk about people sleeping rough. And it says for people sleeping rough in 10.6 of the Code of Guidance, if you want to go check it out, basically, if someone is actually living in the district, as in they're rough sleeping in the district, they're accessing services in the district, they're accessing probation in the district, then they have a local connection, basically. But it gets more interesting than that because not only is it possible to have no local connection, it's also possible to have multiple local connections. And so, in either case, you can basically choose where you want to live. So, let's say you've got no local connection at all, you can basically approach any council in the country. The initial stage of the application process happens to everyone anyway, or should do if they're following the law. And if you have no local connection elsewhere, then the council has nowhere to refer you back to. So it's stuck with you basically. And equally, where you have multiple local connections through family, I have seven because I've got my own family connections plus my wife's, and they both kind of add up to kind of various local authority districts. I can if my house burned down, I can basically pick and choose which council I wanted to approach for homeless assistance. Yeah, and as someone just said in the chat there, you don't need local connection if you're fleeing domestic abuse. So in that sense, the way it works, the legal mechanism is that whilst you might have a local connection to Area A, if you're at risk of domestic abuse in Area A, then Council B can't refer you back to Council A, if that makes sense, if there's any risk of abuse there. So you can see local connection, firstly, is not relevant to the initial duties to accept an application and place in interim accommodation under Section 108. But also you'll see that people do actually have more choice than they might realise. And it matters because waiting times for housing varies ridiculously around the country. Surprise, surprise, or no surprise, that the worst waiting times are in London. This is a map here I've compiled for 2-bed properties. I appreciate probably most people you work with will only need a 1-bed property, but the kind of the pattern's basically the same. And the average waiting times for homeless applicants owed the main duty, rather kind of a bit of a mouthful there, it varies between 6 days in Basset Law and about 15 years in Croydon. I think Croydon's the worst I saw for a 1-bed. What this means is if you have local connection to more than one area, part of your consideration of where you want to apply to is going to be based on the average waiting times. Because the other thing to say is that if you apply to Croydon Council, even if they accept a duty, they're probably not going to house you in Croydon Council. They're probably going to house you somewhere else ultimately. Whereas if you approached one of the kind of bright green areas, you can't guarantee being housed in those areas, but the council almost certainly will do. So, as I say, you can. I mean, I'm going to put the full numbers into the chat before the end. You can have a look yourself at kind of how much they vary and give you an example of how this works in practice. So, I early this year, a lady who was 8.5 months pregnant fled to Bedford from London, fled abuse, and she approached Bedford Borough Council, who gate kept her for a week. But anyway, got her to be housed by Bedford, and then kind of had the time to sit down with her and said, look, you haven't got any ties to Bedford, you just come here pretty much randomly. Do you not want to approach Central Beds, which is 10 miles down the road, a much nicer area? It's got half the waiting time. And she was like, hell yeah, get me there, please. So we withdrew the application to Bedford, approached Central Beds, who also gate kept her for about a week or so. But once we got that cleared up, they followed the law and they accepted the main duty within 2 months. And she is almost certainly in her final accommodation now, as in she's in settled accommodation now. So, again, there's loads more to say about this sort of stuff. There's lots of videos on the YouTube channel about this sort of stuff. But someone coming out of prison, as I say, they might not have a connection anywhere, or they might have multiple connections. That's a good time to work out, okay, where do you want to go? Something that we see in the Code of Guidance is that, if I go down a slide, I'll come back to that one. So, Chapter 17 of the Code of Guidance is a good example of where the guidance is not legally binding in the sense that it tells councils to consider things, but it doesn't actually make them do it. So let me explain what I mean by that. So in 17.58, in some circumstances, there will be clear benefits for an applicant of being accommodated outside the district. Another example might be, there's one about domestic abuse in there, but another example might be where, upon the advice of the relevant provider of offender management services, probation and community rehabilitation company, or youth offending team, ex-offenders or drug and alcohol users would benefit from being accommodated outside the district to help break links with previous contacts, which would exert a negative influence. Now, this falls short of telling councils they have to do it. It just basically says they have to consider it. So a good council will absolutely take this sort of thing into consideration. Even Bedford has a reciprocal arrangement with Luton, where if someone needs to leave Bedford to make a fresh start, they'll swap someone from Luton. Now, I've got to be honest with you, Luton's not the nicest place on earth, but yeah, the same thing would be possible for councils to make those kinds of links and enable people to break away from those kind of negative influences. Talk briefly about some of this stuff already, so I'm not going to go over this slide now. We then come to intentional homelessness. So again, it's very badly misunderstood. 3 criteria have to apply for someone to be intentionally homeless, and it has to be all 3. That's the crucial thing. And this is actually where I'm going to come back to the question about someone setting fire to their own home in a minute. So firstly, they need to have deliberately done something or failed to do something which led them to become homeless. That can include committing a criminal offence, because you would presume that there's a risk that you might go to prison, therefore lose your accommodation. But it might be setting fire to your own home. It might be not paying the rent. It might be committing antisocial behaviour. It might be committing domestic abuse or something. And the accommodation is available, which it probably will be. But crucially, and thirdly, it would have been reasonable for them to continue to occupy the accommodation, which comes back to this question of, they might have accommodation, but if they can't afford it, it's not suitable for their medical conditions, it's not safe, it's not in a reasonable state of repair or whatever, then potentially it would not be reasonable to continue to occupy, and therefore you can't be intentionally homeless. Now, treat what I'm about to say with a pinch of salt, because I'm going to go back to that question. Would someone who sets fire to their own home be intentionally be in priority needs? Our first kind of response is yes, even though it seems weird. But then also you'd still have to ask the question, was it reasonable for them to continue to occupy to establish whether they're intentionally homeless? Now, let's say that accommodation was completely unaffordable. It's not reasonable to continue to occupy. And so legally, as weird as it might sound, you might actually have a situation where, technically speaking, and therefore legally speaking, the council would potentially owe a duty once that person comes out of prison for the arson. Again, treat that with a pinch of salt. We're not kind of testing, we're not going to say that's all tried and tested idea, but I think it does kind of help understand how these different tests and how the different concepts can actually combine to get some rather unexpected consequences. Certainly, I've worked with cases where a perpetrator of domestic abuse who clearly has done something deliberately which led to them losing the accommodation is not actually intentionally homeless because there was something else going on. Might have been they've been cuckooed or something, and therefore it was not reasonable to continue to occupy the accommodation, and therefore they can't be found intentionally homeless. Let me just come to the chat briefly. The question here: so will the council pick up the referral quicker to allocate a housing officer to a person in prison and the community if we make a homeless application rather than the duty to refer? Currently in Halifax, allocating waiting times is 4 to 6 weeks and maybe longer. So a good question. I guess it's important just to kind of reiterate that making a duty to refer does not actually result in, or doesn't necessarily result in, Section 108 interim accommodation even being considered. So I think the answer has to be you're going to get a quicker, more robust response if you make a homeless application rather than just do a duty to refer. But just bear in mind that councils knowingly break the law every day. So in a situation, let's say that in the example in the question there about Halifax, let's say that Halifax had a waiting time of 4 to 6 weeks to actually accept homeless applications rather than a duty to refer. That's not unusual, probably. Councils do kind of say that sort of thing, but it is definitely not lawful. You could definitely challenge that and say your duties to accept a homeless application when a homeless application has been made are immediate, non-deferrable, and so on. Whereas the duty to refer, there's no set timeline. If I was a probation officer, I would do the duty to refer, fill it in, send it off, and then I would make the homeless application, and that's the thing which is actually going to get them housed. That's the thing that actually matters. So you might be thinking, well, what's the point of the duty to refer? Yeah, you're right. There is no. It's a bit ridiculous, really. I would assume that when they wrote the Homeless Reduction Act, that at some point it was going to be better than that, and then they realised it was too expensive to follow the law or house people, and so they sort of rolled back on it a little bit. There's other examples of how they did that with the legislation as well. So there's another slide I really should have put in here. I'm going to just briefly mention it from the Code of Guidance. Check out 9.17 of the Code of Guidance, because basically it says that generally act should not be considered deliberate, where, for example, the act was the result of limited mental capacity or fluctuating capacity or an assessed substance misuse issue, or if that person was under duress. Now, I've worked with quite a few people now, not loads, but quite a few people who were convicted of things like kind of intent to supply class A's or something, and it turned out that they were their property was being cuckooed and they were being kind of they were under duress. They were being forced into it. The information didn't come out until after the case and after they'd actually come out of prison. But when we reapproached the council, we actually said, hold on a minute, there's new information here. They weren't just kind of dealing drugs because they felt like it. They were dealing drugs because they were absolutely terrified of this gang, and actually that was enough to show that they weren't intentionally homeless. So yeah, check out 9.17 as well. It's really good. And then finally, oh, no, in fact, I have got it. There it is. Sorry, slides are a bit higgledy piggledy, but that's the bit it says. So again, I'm not going to say the same thing again. But there's two more things to say about intentional homelessness. One is that if you are in priority needs, but you're intentionally homeless, the council still has a duty to house you for 3 months. When I first learned about housing law, having worked in the sector for 8 years by that point, and I read that, I was like, what? That's the exact opposite of what I've been told. I've been told repeatedly that if someone's intentionally homeless, there's no help for them at all. That's a lie. There is a duty under Section 190 to house that person for a short period of time. And in practice, that short period of time it's at least 3 months, really, effectively. Now, that is designed specifically to catch people who might be vulnerable, give them a little bit like kind of same sort of idea as CAS 3, really. Give them a bit of stability, give them a bit of time, give professionals a bit of time to actually find out other housing options. But this is why, even if you're definitely intentionally homeless, even if you have set fire to your flat and, kind of, and you were going to be found intentionally homeless down the line, it's still worth making an application now, because the council has a duty to provide suitable accommodation to that household or that single person for about 3 months in practice, maybe a bit more. And then finally, just a kind of example of intentional homelessness in practice. So this is kind of building on this idea here about assess substance misuse problems. So Kendall v Westminster, in this case, she had a long history of drug and alcohol abuse. I'm just paraphrasing here. She lost accommodation a few years before. The council decided that her last out of accommodation had been the property from which she'd been evicted for rent arrears. She explained that she'd failed to deal with housing benefit and other matters at the time because of chronic drug addiction. The judge allowed the appeal. The council had wrongly failed to take the code of guidance into account, and given the conduct of the claimant in 2002 suggested aberrant conduct arising from a drug addiction. So that's an example of where potentially drug and alcohol use, assessed drug and alcohol use, may be a defence in effect against being found intentionally homeless. So I think that's it. Yeah, that's just my notes here. So yeah, ignore that. I'm going to delete them, in fact, because that's going to confuse everyone. Let's just see if there's anything else I just want to say at this point. It's interesting, I think, about how few cases there are that involve people coming out of prison and kind of being involved in this kind of sector. You might wonder why I'm saying that. I mean, I think basically the majority of people in that situation would be owed duties by the council. I suspect the reason we don't often see them coming forward through cases and kind of case law and examples that we see in the code of guidance is that, generally speaking, people with offending histories don't get the same level of support as other people might get. Now, you might think I'm being controversial there, but effectively, if we have a right to put people in prison when they break the law, which we do, we also need to make sure that the law is working properly when they are released. So in one sense, it's no good sending someone to prison when they break the law, but then treating them unlawfully subsequently. I think that kind of undermines the kind of whole thing that we're trying to do. It's my opinion.